Well, I think we can start. We've got about just everybody here. Welcome everyone to this special webinar on recent amendments to the Independent Commissioner Against Corruption Act in South Australia, which is being held jointly today with the Stretton Institute for Public Policy and the Centre for Public Integrity, which is an independent think tank dedicated to preventing corruption, protecting the integrity of our accountability institutions and eliminating undue influence of money in politics in Australia. I'm Professor Lisa Hill and I'll be moderating today. Now, we have three very special guests on our panel today who together bring a wealth of expertise on the topic. But I would like to note before we start that this webinar is not about the fine points of the legislation, but rather it's about ICACs more generally and the broader principles at stake for this new legislation here in South Australia. So the broader principles at stake for the public interest. I'll be taking questions at the end after the three speakers have spoken, and we'll get through as many as we can. But can I remind you to please use the Q&A function rather than the chat function for doing that. Any questions we don't get to, I'll pass on to the panellists and they'll do their best to respond. Now, let me just say a few words about our speakers. First of all, we have Stephen Charles. Actually, Anthony will be going first, but I'll speak about Stephen first. Stephen Charles QC is a former judge and a leading expert on political integrity, advising the Baillieu government on the establishment of Victoria's own Ibac, the Independent Broad-Based Anti-Corruption Commission, and he's advocated for the establishment of a National Integrity Commission. He was involved in the Kingsbridge Royal Commission and the Westgate Bridge Royal Commission, and he served as chairman of the Victorian Bar and its Ethics Committee, as well as being president of the Australian Bar Association. In 1995, he was appointed a foundation judge on Victoria's Court of Appeal, and he currently serves as chair of the Preliminary Evaluation Committee, which reviews applications for silk in Victoria right now. He served as a board member of the Centre for Public Integrity, of which I'm also a member, since its inception, and he's also a board member of the Accountability Roundtable. And in 2017, he was made an officer of the Order of Australia for distinguished service to the law and the judiciary. Anthony Wheely QC is a former judge who worked on the New South Wales Court of Appeal from 2000 to 2012. And he has a lot of experience working with integrity agencies, including as former Assistant Commissioner to the New South Wales ICAC, a law reform commissioner and chair of the New South Wales Crime Commission. He's also a member of the National Integrity Committee, a former chair of Transparency International Australia, and the current chair of the Centre for Public Integrity. And on the artistic front, he's chair of Bach Academy Australia, and he loves South Australia and his wife, and he regularly brings 70 or so people to Adelaide each year for the Adelaide Festival. So thanks for loving us. We like it here too. Finally, we have Professor Adam Gregar. He's Professor of Public Policy at the University of Adelaide and also Director of the Stretton Institute. He's an expert on corruption, and his latest books are Handbook on Corruption, Ethics and Integrity in Public Administration 2020 and Understanding and Preventing Corruption 2013 with Tim Prenzler. He was the longest serving director of the Australian Institute of Criminology at the Commonwealth level, and notably in 2020, he was awarded the United Nations Office on Drugs and Crime International Anti-Corruption Excellence Award for Academic Research and Education. So we have an extremely eminent expert panel here today. Before we go on and start with Anthony, I'd like to note that we invited to this webinar the sponsor of the ICAC bill, the Honourable Frank Pangallo, and also the Attorney General of South Australia, the Honourable Vicky Chapman. Mr. Pangallo has declined and the Attorney General is unable to attend this event due to a prior commitment, but she sends her apologies and wishes us well. So our speakers will now speak for between 10 and 15 minutes each, after which we'll start taking questions and fielding them as best we can. So Anthony, can I hand over to you to talk about this change to our local ICAC, please? You're on mute. Yeah, thank you.
I was just teasing you. Look, thanks very much, Lisa, and thanks everybody. It's really a great pleasure to have this opportunity to address this important issue. I'm just going to make a brief sort of historical mention of the facts that led to the legislation being passed in October this year. I don't come from South Australia, so there's a lot of minutiae and nuance that I possibly don't understand, but I just wanted to sketch it briefly because I think it's important. Let me say by way of opening that the Centre for Public Integrity does have concerns that the significant changes to South Australia's ICAC legislation and other legislation in that regard do pose a threat to integrity in South Australia. And secondly, this sort of move constitutes a threat to the establishment of a robust and effective national anti-corruption body. National bodies, Stephen will talk about this, but I think it's fair to say that right at the moment there are a few of the state and territory anti-corruption bodies that are being attacked generally by politicians or by people who've been found guilty of corrupt conduct. Now, the history of this, as I understand it, doesn't centre only on this, but Operation Bandicoot was an operation that took place in South Australia. It involved allegations of dishonesty on the part of a group of police officers. After the matter had been investigated, the Director of Public Prosecutions decided to launch prosecutions against the group of police officers. And the matter, first of all, went to a highly contested battle in the Supreme Court over what evidence could be or could not be admitted. And that particular piece of litigation was resolved in favour of the Director of Public Prosecutions. So the matter went to trial, and I suppose much to the disappointment of the prosecutors, two of the defendants were found not guilty, and one was the subject of a hung jury. And following upon that and deliberations, charges against two other people were dropped. So it was a loss for the prosecution, but it did have some tragic personal consequences for some of the people involved. So it became quite a notorious matter and one evincing public sympathy. However, just in general, can I say that it's not an unusual situation with anti-corruption agencies that they will conduct an investigation and determine that there is inappropriate conduct and refer a matter to the Director of Public Prosecutions. And it's not unusual, although perhaps when I say not unusual, it's certainly not rare that a prosecution will be launched and it will not succeed. And one of the reasons for that, people don't often understand, is that an anti-corruption agency doesn't act as a collector of evidence for prosecutions. It's not part of the criminal justice system. It's part of the executive, and it's given special coercive powers to try and get to the truth and uncover corruption. So it doesn't make findings of that anyone's committed a criminal offence. It's prohibited from doing that. So the difficulty there is that the evidence that ICAC gathers is inadmissible, generally speaking, in a criminal prosecution. So if I were investigated, I might well be forced to admit my guilt or complicity in corrupt conduct, but notwithstanding that I've admitted it, that admission can't be used against me in a criminal prosecution. So it's not surprising that sometimes prosecutions do fail. But here, as I say, there were tragic personal consequences, and I think it elevated the issue more highly in people's mind. So a parliamentary committee, the Criminal and Public Integrity Committee, made recommendations about ICAC in December 2020. I've had a look at them. They were very substantial recommendations, and you could see the sense of a lot of them. However, nothing much happened. And then suddenly in October 2021, a bill was presented by Mr. Pangallo, and as I understand it, it received express delivery, is how I'd probably put it. 24 hours, minimum debate, lots of amendments thrown around, and suddenly it's passed and it now has the royal assent. But it certainly took Commissioner Vanstone by surprise, and she immediately responded to say that she regarded the resultant piece of legislation as one that decimated the prospect of uncovering corruption in South Australia. A pretty important claim by a very experienced and well-regarded former Supreme Court judge and the current Commissioner of ICAC. So I just wanted to briefly outline, as I understand it, some of the matters that have concerned Commissioner Vanstone, because, and there's been publicity about this, she's spoken publicly, so I hope I don't do her an injustice in trying to put these very briefly to you. I won't cover everything, just the main ones. I think, first of all, the one thing that happened was that ICAC in South Australia can no longer deal with misconduct and maladministration. Its remit under the previous legislation was to deal with serious misconduct and maladministration, but it can't do with any of those now. And those matters have been perpetually hived off to be dealt with by the Ombudsman. One problem that's emerged, of course, is that as far as parliamentarians are concerned in South Australia, there's no code of conduct. There is one for ministers, but not for the ordinary member of parliament. So the definition of misconduct really, as far as parliamentarians are concerned, is really lacking, because if there's no code of conduct, there can't be any misconduct. And maybe someone just overlooked that, but it'll be interesting to see how quickly a code of conduct might be passed through Parliament. I wouldn't mind betting it'll take a lot longer than did the legislation which we saw fly through in early October. And bear in mind also that the Parliamentary Committee back in December 2020 had recommended that there should be a code of conduct for politicians, but it hasn't happened for the ordinary members of Parliament yet. But more importantly, I think, just taking a broad view of it, I think the worry is that it was a good thing to have the whole of the integrity of public administration under the umbrella of one organisation, albeit with the capacity to liaise with and refer matters to other agencies such as the Ombudsman, and to also to liaise with and work with the Office of Public Integrity. All of that now has gone, so ICAC's sort of left denuded on its own, but without the intelligence and other capacities that it once had. And I can't see that that's a good thing for South Australia. Also, I think the second and perhaps most important thing is the limited definition of corruption that ICAC can now investigate. It once had a broad remit to look at serious offences, but really it could look at any serious offence. It can't do that anymore. And I think that limiting of the definition would be regarded as a real erosion of its capacity to uncover corruption. And the third thing that I think is so important is that it's effectively lost its intelligence and educative ability around the whole issue of corruption. Of course, it can still, as it were, report to politicians and public officials about serious corruption, but it can't do that in the area of misconduct and maladministration. And, you know, sometimes I think what might begin as just an instance of misconduct can, upon examination, be seen to be quite serious corrupt conduct. It's very hard to draw a bright line between those things. But I think the inability of ICAC to do that very important task of providing education and guidance to public officials on a broad front is a real setback for the state. Other smaller things are that it can't conduct its own initiative investigation as it once could. It can't deal with the prosecutor directly. That seems an odd thing, because after an investigation's finished in most agencies around Australia, the ICAC can refer matters to the Director of Public Prosecution, so there's a direct link between them. Still the prosecutor's job to conduct prosecutions, but that link's very important. Here it's severed, and what happens under the new legislation is that, having finished an investigation, the Commissioner must hand it over to the police for further investigation by them, and they then report to the Director of Public Prosecutions. It hardly seems a satisfactory form of protocol if you're dealing with an investigation into corrupt police officers. So you then refer it on to the police and they decide whether it's to go any further. Strikes me as a little bit odd. And I might say it's in direct contrast to a Court of Criminal Appeal decision that was given in South Australia in 2020, September 2020, in which the very opposite was the decision that was made. Of course, courts don't know everything, and parliaments, it may be thought, do. But I do suggest that, once again, that's a very odd thing to do. I think that there are some other things, but I won't deal with them all. The Commissioner, for example, can no longer make the sort of public statements that she once could. And that severely curtails, I think, the public participation and knowledge in what ICAC's doing. I mean, it's always been limited, but on this issue, it's really silenced the Commissioner. That's not good. In addition, there's extraordinary powers given to a reviewer to sort of superintend ICAC. There's no doubt that ICACs around the country should have proper supervision and oversight of them. Accountability is very important. But as I understand it, the reviewer now, under these extraordinary powers, can get search warrants and search high and low through the Commissioner's home to find out material that might suggest that ICAC's been misbehaving itself. Well, I wonder whether that's going a bit far, but there it is. So they're the matters, and I think one would say that there's some really peculiar things there. The thing that mostly sticks out, though, and this is really the point I want to make before concluding, is that you would think that these changes come about because of the recommendations made by the Criminal and Integrity Parliamentary Committee. But I think with one or one and a half exceptions, they do not. And yet the very act is entitled an act to implement the recommendations of that committee. And yet most of the matters I've put to you, admittedly not all, but most of them are not the recommendations that the committee made at all. So it leaves us wondering why. And I think it creates a perception. Maybe it's unfortunate, but it creates a perception, and I hope it's not the reality, that these changes are there to protect politicians and perhaps the police from proper scrutiny. I mean, if that were the case, this could only be to the detriment of integrity and honesty in South Australia. And I think it will have a chilling effect on the ability of the South Australian ICAC to uncover corruption and misconduct in the state. So they're my thoughts on it. As I say, I'm a stranger to the area, and maybe I'm wrong about some of those things, but we are, as the Centre of Public Integrity, we are concerned about them. Thank you.
Great, thanks so much, Anthony. Now we'll move on to Stephen Charles for 10 to 15 minutes, and he's going to give his thoughts on what's just happened.
Thanks, Lisa. I was just unmuting. I want to deal with a couple of matters in particular. That's the breadth of the jurisdiction of an Ibac. And secondly, I want to deal with the question of public hearings. Now, I can do that really, I hope, helpfully by reference to Christian Porter's exposure draft of a National Integrity Commission, which the Coalition has put forward and has been championing, because it really exposes the problems that arise with an anti-corruption commission. Now, first, the question of the breadth of jurisdiction and the definition of corruption. The Commonwealth exposure draft is a body which is divided into halves. Half of it deals with law enforcement bodies, which would include the police and border force and matters of that kind. And that half of the exposure draft provides for a very strong and forceful integrity commission, but only that half. The other half, which deals with the remainder of the public service and parliamentarians is a flappy pancake that would not expose any corruption that might happen to exist in the federal area. And let me show you why. So far as the definition of corruption is concerned, and the breadth of that half of Mr. Porter's body is concerned, there has to be a connection with a number of crimes, a reasonable suspicion of a crime, and it is only that sort of matter that the body could simply start investigating. Now, the problem with that is that corruption is something which is much wider than crime. It may not involve a criminal offence at all. Now, the sorts of matters that are not criminal would be the question of the consequence of major political donations, favour for favour, the contracts for friends that a minister may want to award. But the best sort of examples of it would be, for example, the sports rorts, the car park rorts, the matters of that kind, which when you look at them, you see that the coalition has, in relation to the sports rorts, picked out a number of areas which it would be good to give a donation to or a grant to, because it would be electorally helpful. It's called pork barrelling. Now, there's no obvious offence in relation to that, so that Mr. Porter's body wouldn't be able to investigate the sports rorts or the car parks rorts, matters of that kind, at all. It requires us to find a helpful Auditor General who goes through these things in enormous detail, and then is able at the far end to say, well, no, that was something which was done purely for the party's electoral purposes, which is, of course, we would say, quite improper and within the Transparency International definition of corruption. Now, if you have a body of that kind, where there is the necessity for investigation of a crime, you would not have been able to investigate all the coal mining licenses in the Bylong Valley in New South Wales, which led to the prosecutions of Mr. Obeid and members of his family, and Mr. McDonald, the Minister for Mining. That started because of an anonymous telephone call which said that there's something strange happening with the coal mining licenses in the Bylong Valley. But at that point, no one had any information which would have suggested a proper examination of a criminal offence, so that it simply could not have started. Now, therefore, what you've got to find is a wider definition of corruption, which does not necessarily involve a criminal offence. And of course, you would need to limit it, because what you should be examining must be something which is either serious or systemic, and certainly not trivial. Now, turn from there to the question of public hearings. The South Australian body has never had the ability to hold public hearings, which sets it apart from all the other anti-corruption commissions in this country. The best examples of those that do, of course, are the New South Wales ICAC and the Victorian Ibac. Victoria's body holds much fewer public hearings than the Sydney body, partly because of Section 117 of the Victorian Act, which requires there to be exceptional circumstances before public hearings can take place. Now, a good example of what a public hearing can achieve would be the Victorian Ibac's examination, Operation Ord, of the Education Department. This took place in 2013, shortly after Ibac was set up. At that point, Victorians thought that there was no such thing as corruption in our state. And what that set of public hearings resulted in was a demonstration that a group of very senior public servants at the head of the Education Department had set up a system of banker schools where large sums of money were sent to a particular school in a certain area as the banker for that area. Nothing wrong with that, perfectly reasonable process. But then instead of passing on all the monies that were going to the bank of school, those senior public servants were siphoning off huge amounts, millions of dollars from it, for a very high and engaging lifestyle for themselves, holidays, Grange Hermitage, and anything you like. Now, that was corruption of a kind which was demonstrating to Victorians for the first time that there certainly is a lot of corruption, and it was followed by a string of complaints of different kinds of corruption. Witnesses came forward, but above all, the Education Department itself realised that there was corruption within its system, and while these hearings were actually taking place, they changed the rules and regulations and procedures of the Education Department so that they could never happen again. Now, those are the sorts of things which public hearings can achieve. Likewise, the investigation of the Casey Council, where it's alleged that there was an attempt to change the zoning of certain land from industrial to residential, the effect of which, had it occurred, would have been an increase in value of the land in excess of $100 million. And there were politicians of both sides who had been involved in the attempt to achieve that rezoning. Only when it was made public was there sufficient opposition within the community to stop that happening. And in the resulting investigation, it's politicians of both sides have been called into the witness box. The community has been made aware that this sort of thing was happening in municipalities. And what is happening in that particular case, the council municipality, would almost certainly be happening in other municipalities around Victoria. It's a matter of enormous importance that these things should be made public. Now, that is the sort of thing that public hearings can achieve for the community. Now, the most anti-corruption commissions do have that power for the reasons that I've given. The question of the use of public hearings by royal commissions has been repeatedly considered by the High Court. At least 3 Chief Justices of the High Court have said that public hearings in proper cases are essential for the purposes of anti-corruption commissions. After the New South Wales ICAC was examined by Murray Gleeson, the former Chief Justice, and Bruce McClintock, who was then the inspector, they also said that you should not remove the power to have public hearings from the ICAC. In proper cases, it serves an essential purpose. Now, of course, these things can cause damage. Of course, there must be protection against matters of that kind. Of course, an anti-corruption commission must have repeated private hearings first to ensure that they've made a proper examination and know what they are going to expose to the public and do not affect people's reputations. There should be a parliamentary committee supervising the activities of your anti-corruption body. There should be an inspector. The operations of the anti-corruption body should be subject to the control of the Supreme Court, or if nationally, the Federal Court. And there should be the possibility of appeals against an improper finding to the relevant court. Now, one of the things that is repeatedly complained of in relation to the ICAC is that it has had hearing after hearing which has damaged people's reputations. And it said it's cost us 3 excellent premiers. Now, that is absolute nonsense. In the case of Nick Greiner, who set the body up, he was involved in what was alleged to have been an attempt to bribe a member of his parliament to give up his seat on the promise of appointment to a position in the Environment Protection Authority, which hadn't been advertised and for which there had been no proper investigation of abilities. Now, the matter went to Ibac, where the commissioner found that there had been a corrupt action, even when the New South Wales Court of Appeal allowed an appeal from that finding. They did not say that the finding of serious conflict of interest was wrong, that they accepted that it plainly had been. And furthermore, Mr. Gregar then went off to an enormous string of board positions. He's at the head of the business and legal communities in the state. His reputation is completely untarnished. And the same goes for Mr. O'Farrell, who made a mistake in his evidence, went home, discovered he'd got the evidence wrong, and resigned in embarrassment. If he'd come back the next morning to ICAC, said, "I'm sorry, I got that wrong, I apologise," and the position was this, no one would have complained at all if he'd stayed there. He chose to resign. In relation to Ms. Berejiklian, I suggest to you that what ICAC is doing at the moment is an entirely proper examination of a state of affairs which suggests that there's been improper activity in relation to the activities of Mr. Maguire, who's shown to have been behaving improperly in a variety of different ways. All these allegations of the damaging of reputations, when you examine them, do not stand up. Now, public hearings is something which South Australia has not had. I suggest to you that it's a matter with which careful consideration should be given in South Australia to including in any future amendment of the legislation, and that with proper protection and careful examination beforehand of whether there is a real public interest in a public hearing taking place, they then perform a very important role in the activities of an anti-corruption commission. Adam.
Thank you, Stephen. Before Adam speaks, can I just remind you that if you are starting to think of questions, put them into the Q&A function and I'll queue them and then we'll get to them after Adam's spoken. So thank you, Stephen. Now we'll go on to hear what Adam Gregar has to say about this. Thanks, Adam.
Thank you very much, Lisa and the other speakers. You've outlined a whole range of issues that are really relevant and central to what we're dealing with in South Australia. But to help us put a fair bit of this into context, I thought I might talk a little bit more about anti-corruption agencies a bit more generally, and then we can see the sort of thing that's happening here. Until COVID hit, I used to go to a lot of international conferences and do a lot of talks to different sorts of audiences. And wherever I went, people would say to me, "Boy, are you lucky coming from Australia where there's no corruption." And I'd say, well, it's not quite like that. Corruption, there is corruption in Australia. It's different to what you may have in your country. But whatever way we look at it, Australia is not a high corruption country. We don't have bags of cash being handed to politicians and public servants for them to do their job. That's not what we have. But what we do have is a very interesting example of rich country corruption, which is very different to poor country corruption. And in poor country corruption, yes, we do see very corrupt institutions, we do see corrupt judiciaries, we do see politicians easily being bought. In rich country corruption, the currency is different. The peddling of influence rather than the criminal behaviour, the conflicts of interest, the poor accountability, the procurement irregularities. And the sorts of examples that Stephen gave show that, yes, whatever processes you have in place, it is often likely that there will be somebody on the make. And we need certainly to be able to understand the opportunities that those people have, the culture, the structures, all of those things that allow those people who might be on the make to subvert the whole basis of public integrity. So the first question we need to work out is, are we dealing with a situation where corruption is the norm, as happens in many poorer countries, or where it is absolutely an exception, which is what we have in Australia? However, the way we respond to it and have responded to it is, on the one hand, a building of integrity, and on the second, a set of watchdog agencies that are able independently to identify issues. Now, as I said, Australia is not a high corruption country. It's very hard to measure corruption, and Transparency International, the global NGO, has a corruption perception index. And until about 2012, Australia was always in the top 10, was ranked at around number 7 out of 180, and that was pretty good. But we've slipped. We've slipped to numbers around 12, 13. Yep, look, 12 or 13 out of 180 is pretty good. There's no doubt about that. But to have slipped, and it is a perception index, to have slipped requires us to think why and how and what's led to that perception and what are we doing about it. So if we start to put it into context, Australia is a signatory, as are numerous other countries, to the United Nations Convention Against Corruption. The United Nations Convention Against Corruption in Article 6 and again in Article 36 requires signatories, countries that have ratified the treaty, to set up an anti-corruption agency, to ensure that the anti-corruption agency is independent, to ensure that it's well-resourced, and to ensure that the people who work in it are well-trained. And so we've got two sorts of approaches generally to anti-corruption, and one is to either criminalise and the other is to prevent. And clearly the two come together in some way. And what we've got in South Australia now is a situation where we're saying we are criminalising. That is the only criterion. Criminalising, and then you've got an organisation that deals with something that may be a criminal matter and it goes through a set of processes. But in rich country corruption, as the previous two speakers have pointed out, criminal offences aren't the body, the corpus of the corruption that we have. Anti-corruption agencies, however, are a fairly recent phenomena. The New South Wales ICAC started in 1988, and among anti-corruption agencies around the world, it's a pretty old one. The South Australian one started in about 2013, and we've heard some of the differences between the various powers. But as I said before, for an anti-corruption agency to be effective, it needs to be a public body, it needs to recruit people on merit, it needs to be independent, it needs to be well-resourced, it needs powers to investigate, and also very significantly in the United Nations debate, its leader needs to be able to be free to talk to the media. And so what we've got, as we start to think our way through anti-corruption agencies, is what do you want them to do? What do you want them to do? Do you want them to chase every minor little infraction, to go after the rats and mice? Do you want them to deal with the big picture issues only? Do you want them to deal with criminal matters only? And one way of describing it, in a way, is do you want them to bark or do you want them to bite? You know, I've talked a lot about whether you have them as guard dogs or as watchdogs. You know, barking, and most of our anti-corruption agencies in Australia, they bark. They don't bite. Somebody else does the biting. You refer to the Director of Public Prosecutions. The judiciary makes the determination in the end if there's a case to answer. But barking gives them that entree, gives them that way forward to be able to investigate further, to get other relevant authorities involved. But what we've got is a question. We've seen with the South Australian legislation significant pushback against the ICAC, And the response, or the thing that organized the pushback to some extent, said, well, it was because it had overreached. So we've got this balance continually between pushback and overreach. What do you want it to do? And how far should it dig around in the weeds? A colleague that I've worked with over the years, John Kwa, at National University of Singapore, talks about anti-corruption agencies in sort of three categories. He talks about watchdogs, he talks about attack dogs, and he talks about paper tigers. And what is interesting is many of the anti-corruption agencies are limited strictly to corruption, however it's defined, and usually very narrowly defined. But many of the watchdogs deal with both integrity and corruption. And the first question then in this sort of framework we need to ask is, what's the problem we're trying to solve in our society? When you have an agency, when you've got some sort of intervention, what's the problem that you're trying to solve? And we're not trying to solve a problem of public servants being given huge amounts of cash to make decisions or not make decisions. We're not talking about people in very, very traditional senses. We're talking about breaches of integrity that we can list again and again and again, the breaches of integrity that caused Australia to fall from about number 7 to about number 13 in the Transparency International scale. And what was interesting, in some research I did quite a few years ago now, we looked at all the cases brought to the New South Wales ICAC, the Queensland CCC, and the Western Australian CCC. And there are about 15,000 cases for those three agencies in a year. And these three agencies were the first three to be set up, and they were the ones in arguably the most corrupt states in the early parlance. New South Wales and Queensland were set up following shocking revelations about behaviour in the public sector. But what we found is the overwhelming majority of complaints that were brought, and these are only complaints, not hearings, complaints, were not about corruption. They were about stuff that wasn't right with government, stuff that public servants didn't do correctly, poor service, fiddling at the margins, and in addition to that, many of the complaints also were about criminal behaviour in the workplace, like drug taking or assault in the workplace or theft in the workplace and so on. So most of the work of anti-corruption agencies was not about corruption, and in many cases these were referred on, but it was really about the integrity that we depend on to make sure that government delivers well for the people that it serves. And it's interesting, if we go back to my colleague John Kwa's analysis, he looked at Asian anti-corruption agencies, and he found that Singapore and Hong Kong, were very much watchdog agencies. And if you look at them in the sort of Transparency International scale, they're right up near the top as among the least corrupt countries. China and India were much more attack dog agencies, where the agencies were used very politically, often to discredit or eliminate political rivals or muzzle opponents. And he also looked at Korea and the Philippines, and he saw them very largely as paper tigers, that they didn't do much, they were patsies, they didn't intervene, their powers were uncertain. Both of those countries have very different types of large-scale corruption. And India and China, of course, the attack dog anti-corruption agencies have huge levels of corruption. So the key lessons that we can take from all of this, first of all is, what's the problem we're trying to solve? It seems we're trying to solve an integrity problem and have the ability to solve corruption problems as they arise. And also, what we found, those of us who studied these agencies internationally find that the most important element for an anti-corruption agency is to have political will of the political masters to support it and allow it to do what it has to do. And the other lesson from all of this, to sort of complement political will, is that an anti-corruption agency shouldn't deal just with the symptoms of corruption or lack of integrity, but instead should deal with the causes and the conditions that allow these things to come to the surface. And that includes more than just criminalizing the activities. So thanks, Lisa. That's, I should stop for now.
Thanks, Adam. Enlightening. I like your taxonomies as well in regard to canine species. But it is a very useful taxonomy to bear in mind, isn't it? Look, we've got some fantastic questions here now. I've looked at them all. They're all pretty pertinent to what we're talking about. So I'll just go in order because they're all good ones. All right, we'll start with Michael Bradley, who's first in the queue. If you're still there, Michael. He asked, would it be better to let an ineffective federal ICAC be created and later improve it, or just to block it? And by the way, another participant, Jesse McElvray, have suggested block it because it will take years to get a reform bill up and debated. But anyway, this is a really important issue for us, and this is what's happened in South Australia is making us all think about as well. What's happening with this federal ICAC, and is it just going to be more of the same? So, Stephen or Anthony, would you like to respond to that? You're on mute, Stephen. Thanks.
Yeah, sure. I think that quite obviously, I'd definitely say block it. I mean, the trouble about putting in, I suppose it turns on how ineffective it is. But to take the government's model, if it remains as it is, and that's brought before Parliament in a bill, as I suspect it will be, without significant changes, then I would say we don't want it at all. And you can see, just looking at the South Australian experience, now you've got new legislation. There's criticism of it. It'd be up to South Australians to determine how valid that criticism is. But what are the chances of getting amendments to it quickly? I would say very little. And at the federal sphere, where you've got a real reluctance to have any sort of anti-corruption body, at least on the part of the coalition government at the moment, if they could get a legislation in that was ineffective, they would be averse to any significant changes to it. So my answer would be simply, it's much better not to have a truly ineffective body legislated in the pious hope that it can improve.
Stephen or Adam, do you have anything to add to that? It seems to be the central question.
It's very difficult to amend legislation. Ted Bailey brought in 2011 the first form of the ICAC, Ibac, which was hopeless. And for 3 or 4 years, the Liberal Party fluffed around in embarrassment with that paper tiger. And it was only near the end of term that it started to think about amending the legislation. And it was only when Labor got to it that the legislation was amended after 4 years. Now, it's impossible, really, because the Parliament is the body which has to set up a body of this kind. And if it sets up a bad one, it's very hard to get it to make it work properly.
Yes, I agree. And you'd end up with a paper tiger, and there's enough research that shows that the paper tigers are pretty well worthless.
Seems that way. I have a question now, and I think I'd perhaps ask Adam to respond to this because it requires it involves a kind of hypothetical. But what is the difference, says Jesse McElvray, between a government committing to fund sports clubs prior to an election and an opposition party committing to similar funding in the event that it's elected? Is it just the actual expenditure or the promise if one is elected to spend a barrel?
There are two different stories. If, in fact, an opposition promises something and then wins the election and does it, one would assume for it to do it properly, it would follow a process. And yes, you make promises. It's when you don't have a process, when you manipulate a process, when the process is not transparent, when the process is flawed, then you've got a problem.
Stephen, I see you have an opinion there.
Yes, it's the point is this. Politicians in office think that they have an entitlement to spend taxpayers' money as freely as they wish. They regard it as their own. They were told in the school chaplain cases, Williams 1 and 2, and Pape, that is not so. They have to have a parliamentary, a statutory appropriation. The matter has to be considered by Parliament. What happened with the sports rorts is that they were not only completely unfair for electoral expenditure, they were also quite contrary to the High Court's explicit direction. There was no statutory appropriation for them. The same sort of thing applies to the car parks. This is where I may say the government in Canberra has no particular power to make decisions in relation to car parks. That they decide before an election, we'll hand out money to people who will vote for us if we give it to them. Now, that is the sort of thing that we are saying is corruption within the transparency definition.
And I'd also add there's a broader issue there with pork barrelling itself. Even if the process is utterly transparent, there's still a problem with pork barrelling because governments aren't supposed to be distributing public money in that way. They're supposed to be governing the interests of everybody, and where need is greatest. But that's not normally something that an ICAC would look at. But I would, as a person that thinks about corruption in a broader way. Now I have a question. I wonder if, Stephen, you would start with answering this one. This is from Andrew Podger.
Yep.
And he asked this question: would the Victorian Education Department case and the Casey Council zoning case have achieved the same positive outcome without public hearings? And why were the public hearings needed?
Public hearings are needed for a variety of reasons. They are there to educate the public. They're there to educate the public service. They're there to make the community see that allegations of corruption are being dealt with properly. And above all, they are there to deter. Now, that first and foremost. Now, so far as the Education Department's concerned, if there had been no public hearings, the matter would have gone into a public report, which would have appeared in Parliament at some point, not necessarily quickly. There would not have been prosecutions for a considerable time. The report would have come out. It would have very briefly blackened someone's name. But then Nino Napoli is only now 7 or 8 years after the event being dealt with in court proceedings. Now, for each of those reasons I've put to you, I think public hearings were essential. The same thing, if there hadn't been a great public brouhaha, the Casey Council rezoning would have taken place, and the likelihood of the same thing happening in other councils around Victoria would have been serious.
Can I add something?
Yeah, sure.
Can I comment on that one? Public hearings are important, and making the material available is important. Now, my two colleagues talking have been, members of the judiciary and making important judgments. I just teach a bit. And what I've done with the Victorian education case, the Victorian Education Department then embarked on an integrity building process, wrote a report, and I have taught all over the world in numerous countries from that Victorian report, saying, look, here's a department that lost its way, stuff didn't happen, and it wasn't just the criminal offence of moving the money, it was the whole culture, it was the accountability process, it was the way in which senior people dominated junior people. So I've used that Victorian report all around the world to teach when I've done courses for people from numerous countries. And even in Australia, the former secretary of the Victorian Education Department, who came in after the event essentially to clean it up, Jill Callister, she and I have co-taught for the Australian New Zealand School of Government. We've taught a lot of public servants and used those case studies for better practice. So there's a very important role coming out of that work. So, it serves a useful purpose, not just a public hearing purpose, but it goes on from there.
Thanks, Adam. Perhaps I'll ask Anthony if you would like to answer this. If not, we'll pass it to someone else. But here's a question from Jeff Ibbotson. And he says, the Auditor General did expose sports and car park rorts. What are the extra benefits of having an ICAC to investigate such activities? So we do have an Auditor General to do some of this work. What does ICAC add?
Well, two things, I think. First of all, the Auditor General is not concerned with uncovering corruption. He's really concerned with performance standards. That's his expertise. He doesn't have any expertise in relation to uncovering corruption. People like the New South Wales ICAC have a host of investigators who are steeped in experience of uncovering corruption. The Auditor General doesn't have that, and he's not interested in that. So that's the first reason. It's a body with a completely different focus. They do valuable work, and thank God they did unearth these matters federally, because otherwise the public would never have known about them. But the second thing, and this really surprises me, is that with both the sports rorts and the car park scandal in relation to grants of enormous amounts of money, immediately after the Auditor General's finding, senior members of Parliament simply said, we don't agree with him. Paul Fletcher said, for example, straight after the car park rorts, no, these decisions were made only on the basis of need and nothing else. And that totally contradicted the findings of the Auditor General. My point is, I don't think they'd do that with an ICAC. I think they'd realise that they were in deep trouble, both with the community and perhaps in other respects, if they treated findings by ICAC, public findings by ICAC, with the sort of contempt they've been treating the Auditor General.
Thanks, Anthony.
The Prime Minister repeatedly said, when questioned at the press club, no, Bridget McKenzie was just doing her job, exercising her discretion as a minister, and the public loved it.
Okay. I shouldn't be laughing.
Yes.
It's visible. I have a question here. I have two questions actually from Diana Walter. The first one may be tricky at this point where we have a kind of a vacuum. And then the second one's probably easier. But the first one from Diana is, South Australian public servants have been told they no longer have a mandatory requirement to report misconduct and maladministration in their workplaces. Where can whistleblowers go now? And what legislative protections are in place for them? And I think that would take someone with local knowledge of the legislative regime here and the reporting regime here. So, but does anyone have anything to say on that?
No, I wouldn't know the precise detail, but I'm surprised at the first part of the question. Is there no obligation on them to report misconduct and maladministration? That seems a very undesirable situation if that's now the case. I assume that if they want to report something, they'd report it to the Ombudsman. And I don't know what protections are available to them in that regard, I'm sorry to say.
The issue, this is, again, the issue that highlights the importance of integrity and looking at ways in which organisations behave with integrity and ways in which organisational leadership expects people to do the right thing and gives them the resources to do the right thing, And I don't know about the protections. Yes, one could report it to the Commissioner for Public Employment. The Commissioner has often talked about the importance of upholding standards and upholding integrity, but it's a loose, wishy-washy sort of arrangement that may or may not lead to a result. And we do know that protection of whistleblowers is a crucial part of our whole public integrity process. But on the other hand, there's also a very important thing where one expects organisational leadership to provide guidance, organisational leadership to ensure that there's tone at the top, that people do behave with integrity, and if there are lapses and breaches, to make sure that there's a structure to deal with all of this. So it's more than just reporting. It's about not what you do, but what you are, to some extent.
Can I just add that without infringing on Stephen's points today, that, I mean, in the model for the federal ICAC, whistleblowers cannot make a complaint about the conduct of politicians, parliamentarians, their staff, or 2/3 of the public service. They can't do it. And that's just extraordinary. They can make complaints, whistleblower complaints about law enforcement officers, but not politicians or the vast majority of the public service. That's a pretty bad thing, I would say.
Diana's second question is a quickie, and I think we all will probably agree on the answer. And she asks, given the speediness of this bill passing both houses, and it was passed with quite indecent haste, what in the view of the panel would be a reasonable time frame to establish a code of conduct for MPs? Weeks, months? Any thoughts? Now? Yesterday?
Oh, well, being practical, I mean, I assume it could be done within a couple of months. I don't see any justification for it being any longer than that. There's plenty of precedents for it all around the states. There's even the Prime Minister even has a code of conduct, although his ministers don't seem to be too concerned about its details. But we do have them around the country, and I would think that there could be a lot of debate about what it should actually say, but essentially it's reporting, benefits you get as a politician, parliamentarian, declaring conflicts of interest and so on. I mean, it's pretty easy stuff, really. I can't see that it should be a matter that would take too long to get fixed up.
A good officer could get a draft this afternoon. A bit of time on the internet, put a few bits together from what's happened elsewhere and lay it out for discussion, and then people can debate and amend.
Yeah, I could get one of my students to whip it up in 5 seconds flat. But anyway.
I give them the afternoon.
Yeah, all right. Okay, thanks everyone. Here's a question from Wilf Prest. It's an interesting one. Is it at all reasonable to regard this overall controversy as resulting from a contest for power between lawyers and politicians?
No. No, it's to my friend Wilfred. This is a contest between politicians who think they are masters of the universe, but entitled to deal absolutely freely with taxpayers' money and the rest of the community.
I think the South Australian, if we're talking about that, I think it is interesting. It's quite complicated. It's complex, and you've got different movers in the circumstances that have led to the passing of this legislation. So I don't think I would see it in the way the questioner has put it, but it's as I say, it's so complicated that you can't give an easy answer to it. I do think that the police didn't want ICAC to do what it's been doing in South Australia in its investigations. I think that Bruce Lander, from what I've read, came under intense criticism when he suggested there should be public hearings. You can call it overreach if you like, that's led to this, or you could say you can look at it another way and say ICAC was scrutinising things that it should have done, but you run into that problem that I mentioned in my opening, namely that sometimes prosecutions fail and people then want to apply the blowtorch to ICAC, but not realising that ICAC is performing a very different function than the courts are. And so it's, as I say, it's so complex, it's hard to know the answer.
You might add that even Christian Porter's very weak schmozzle of a Commonwealth Integrity Commission could have dealt with the problems of the police that caused all that trouble in South Australia. The half of the CIC that is very powerful, which would include the police, can investigate corruption of any other kind and have public hearings and make findings, including findings of corrupt conduct.
Okay, thanks, Stephen. We have this question from Tom Wheeler, and I might actually field it first because I'm not sure if it's an ICAC question, but others might have a different idea. But he asked this question: we're being told that political advertising does not have to be true, i.e. it's legal not to tell the truth. But Transparency International defines corruption as the abuse of entrusted power for private gain. Is there any room for an ICAC or an Ibac to investigate deliberate, deceitful advertising by a politician during election campaigns? And the reason I thought I'd speak on it is because I've just done a bit of work on truth in political and electoral advertising. And we have a law here that's administered by our electoral commissioner with the help of the Crown Solicitor's Office. It's actually quite effective. If you tell a lie during an election in one of your authorised advertisements, you are instructed to take it down, and people generally comply with that. Now, the beauty of that is candidates who are running for Parliament that do not have this entrusted power are still bound by that, that legislation. So it might ICAC might not be able to get that person because there might be just an independent who hasn't been entrusted with anything by a party or anyone else, just themselves. But they would still be captured under that legislation, and we've been advocating for similar legislation to be adopted at the federal level. And as a matter of fact, Zali Steggall, I think, is on the point of introducing a private members bill to that effect at the federal level. But does anyone have any thoughts about whether ICAC should get involved in, deliberately deceitful election advertising and political advertising?
I don't think so. I think it's just a criminal offence. It's really welcome that it's there in South Australia. I think it's also present in the Northern Territory, isn't it?
No.
So, is it not?
ACT just introduced it.
Yeah.
Everywhere has some sort of fluffy rules around truth, but in election advertising, but they're not really binding, and they're always interpreted as affecting the way you mark a ballot. Anything deceitful about marking the ballot, this isn't very helpful when you're doing your preference formation. You're thinking about character and all kinds of other things and policy platforms. So, but ACT and South Australia are the only places that have this proper regime.
Better to leave it to the to the criminal courts, I think. That's my feeling. It's, as you say, it's a kind of wishy-washy problem, isn't it? And the way it's been addressed in South Australia is good, although there's still argument about whether it goes far enough. But once you try and go further, you get into quite murky waters. So my feeling is that it's better just to leave that to the criminal law and see how it develops. Maybe sometime in the future, there may be a need to refine the definitions of corrupt conduct to include that sort of behaviour, but not at this stage, I don't think.
Okay. Here's our final question from Gordon Parbury, and it's directed at Adam Gregar. Adam, on what basis can you claim corruption is the exception and not the norm in Australia, and specifically in South Australia?
Well, I think that everybody in the audience and all of our citizens can go about their daily lives all day today, all day tomorrow, all day yesterday, without a public servant shaking them down for something that they should have as an entitlement. In many countries, you can't get your document, you can't get your kid into school, you can't get to see the doctor, you can't get a job without, you can't do any of these things without paying somebody or whatever. When we compare what happens, and when I teach, I often start with a BBC video that goes for an hour, and it's made in Africa, and it's about appalling living conditions and the bribery that takes place for the fundamentals of everyday life. Then we can, go up a scale to, richer countries than that, countries like Russia and so on, where the state has been totally captured, basically by thieves. You've got many countries where thieves run the state. Our politicians don't loot the treasury and put the money into Swiss banks. So yes, when it does happen, and I'm not saying it doesn't ever happen, it is very much the exception. It's not the norm that we do see in many other countries.
Thanks, Adam. I have no more questions. But Oh, sorry, I beg your pardon, Stephen.
I was wondering, I don't know that we've got a lot of asylum seekers in Victoria. I'm not sure that they would have the same happy confidence that Adam has. When you think of the state of affairs that existed in Queensland before the Fitzgerald Commission, which had been going on for 20 years and which ended up with 4 cabinet ministers, 3 of them going to jail, and one of them, Russ Hinds, escaping only because he died, and the Premier being tried for perjury and escaping because the foreman of the jury was a young national, the president of the local Young Nationals. Mm. Nick Greiner introduced ICAC because corruption was rampant in New South Wales at the time. I think there is a great deal of corruption presently in Victoria, but still it doesn't show its head quite as often as it does in some places overseas, I agree.
And to some extent, that shows the sort of effectiveness of an agency that can bark, because if you tried to write a novel about what had happened in Queensland in the Bielke years, people would say you were making up far-fetched fiction. Yep. It was horrific. And then, we do have CCC, it's different, it's had its ups and downs. New South Wales introduced ICAC because of the systemic, decades-long corruption that had pervaded both sides of politics and was endemic. I think we've risen from those depths. I'm not saying that we don't have any corruption, but we've certainly risen from those depths.
And the way we've treated Witness K and Bernard Collaery in the course of the last 5 years, and the way we treated Timor in the decade before, I think throws the most awful light on Australia and its politicians.
I'd most like to add too that, I think that I think Adam's right. I'd agree with him that when you compare it to other countries, you get Australia's situation in perspective, in a much better perspective. But I do think the absence of a federal anti-corruption agency means that there's a significant lack of accountability at the top of the tree at a federal level. And the shame of that is that if there's a lack of accountability, a lack of transparency, it leads on to a lack of integrity. And that I think means that behaviour gets out of control. And so we do need to control it. And one way is to have a better watchdog at a federal level.
Can I add that there was a report in 2017 arising out of an audit of the Defence Department, where a lot of people said that corruption was rife in the Defence Department at that time.
Thanks for that, Stephen. I think we've come close to the end, unless anyone else has anything else to add. I'd just like to say I found it very enlightening and very stimulating, and I've got a lot of positive comments here from our participants. Can I ask everyone to join me in thanking Anthony